Hope you're doing well. Alright, it's time for OJ. I really have to go and get my daughter to work. I'm running so late today. And I'm just praying once I press play, we have sound. Alright, the little loopy thing is on. And the speed is set. Here we go. I hope we have sound.
100 hours in preparation, yet he had not
Yay.
a single note.
We do have sound.
So I
I'm
don't
so
find
happy.
it surprising that Mr. Kelberg would be unaware. I find it surprising that Mr. Kelberg now would expect that Dr. Bodden has substantial notes. Regarding whether or not the notes that were taken during the examination are discoverable, I would suggest to Your Honor that since those were done at my direction, and since both doctors were here at my request, and since they were aiding me in my presentation
Okay.
of cross-examination,
I have to go
Dr. Lakshmanan,
and take my
that
daughter
they
to
are
work.
clearly privileged
I know we just
and are not
started.
discoverable.
I'll be right back.
And they are
all right?
part of the
Be
work
good.
product that I
I'm
generated
taking you with
along
me.
with the doctors regarding this case, and purely for one purpose, for the cross-examination of Dr. Lakshmanan. So those are not discoverable. We've had 2 requests for reports, and it is my practice with consultants not to ask for reports since they have been working on this case for the last 13 or 14 months. It would be impossible to generate anything short of a book to be a comprehensive report of all the errors, mistakes, and problems that they see with this case. So there are no such reports. As far as the notes that have been taken, I've asked Mr. Blazier to review all the materials. He has done that. He has furnished that to Mr. Kelberg. Mr. Kelberg has been very candid. He's ready to proceed. So are we. They have everything that they're entitled to.
Mr. Kelberg?
Your Honor, that's I hate to say this, a very disingenuous response. Is Mr. Shapiro saying that there are not notes that Dr. Bodden and Dr. Wolf wrote that are in the possession of the defense and not provided to us? As I understand it, those notes do exist. Now they're claiming work product. Well, they didn't claim work product on the notes they sent across. And it doesn't matter whether Mr. Shapiro is the one that requested their presence here or not. 2018C is the only work product that applies in California, and of course Mr. Shapiro can't cite any case that conflicts with the Supreme Court decision in Lines 13 Cal 3rd 500, that even under a work product arrangement, which was the old Collie civil work product application in a criminal setting when we had one-way discovery, I know the court's well aware of the case, 30 Cal 3rd, that by retaining the expert, by allowing the expert to do work on the case, there was a work product privilege that applied. But when Lines says you put that witness on the stand, you waive the work product privilege, as well as attorney-client, because there the psychiatrist was evaluating the defendant, so there was confidential communication. The defense cannot stand here and say we are not entitled to those notes. I don't care what reason Mr. Shapiro had for having Drs. Wolf and Bodden here. The point is, if they made notes, we're entitled to them. And by the way, Mr. Shapiro conveniently does forget that Dr. Lakshmanan provided detailed reports in Exhibits 350 and 351, identifying every injury that was observed, trying to identify every error that was found in his review of the autopsy. Apparently, Drs. Bodden and Wolf were unable to do that, and the real reason, as everybody knows, is they want to ambush us. And everybody knows it's not a secret. That's the way the game is played. Is this going to be a game, or is this going to be a search for the truth? If Mr. Shapiro can give this court a citation to a controlling case from the California Supreme Court that says we're not entitled to it, let's hear it. Let's look at the case. Let's see if it in fact says what he says it will say. Let's see if Lines is overruled. It's not. I submit to the court, this is an area I've done quite a bit of review in. I'd like to think I'm pretty up to date in the subject. And I think the court will find there is no case which says Lines no longer applies in spite of Prop 115 and reciprocal discovery. We're entitled to those notes. This should not be a trial by ambush. Whether I have the skill to cross-examine him or not, right this moment, without those notes, is not the issue. What is the issue is the will of the people to see that this is a search for the truth and to get from the defense the notes that they have. I'll submit it, Your Honor.
All right. Thank you, counsel. All right. I'm going to direct the defense to turn over Dr. Bodden and Dr. Wolf's notes if they are to be called as witnesses. All right. Tomorrow?
Now, I understand Dr. Bodden's going to be possibly on the stand tomorrow morning. Possibly.
No later than tomorrow.
Will I have an opportunity at least to
Yes, you will.
thumb through them?
Yes, you will.
Thank you, Your Honor.
You're welcome. All right. Let's see. Mr. Walsh hasn't made it yet. How about the Mullis issue?
On that issue, I think we indicated before we try to take this issue, we want to, that'll be a subject of discussion, so we'll watch out.
All right. Then we'll await Mr. Walsh to arrive with regard to the IAD issues.
We'll proceed with that.
All right. And let's see, one other matter. Let me see, Ms. Clark and Mr. Cochran.
I also requested to see any exhibits that they would use that were not already marked. Does the court order include that opportunity?
That'll be first thing tomorrow morning.
Thank you, Your Honor.
All right, thank you, counsel. We've just had a sidebar conference regarding scheduling of the various motions that we have to take up. And counsel, I'm going to suggest that we stand in recess at this time until 1:30, and then we'll start taking up the motions at that time. All right?
Excuse me, Your Honor. Mr. Shapiro, I thought wanted to put something on the record. He asked me to stay regarding photographs.
I think I need to take that out of Mr. Calvert,
All right.
Great. Thank you, Your
Your
Honor.
photograph was apparently taken June 16th of 1994 in Chicago, that we have not received.
They have
It's in Xerox form.
They have the Xerox. I will request that a set be prepared.
All right. All right, we'll stand in recess until 1:30. Thank you, counsel. Again, present, the jury is not present. Counsel, one of the motions that we have on calendar, actually we have two for today. We have the Stockdale motion and the IAD motion. And previously, when this matter was submitted to the court, I advised counsel and Mr. Simpson at the time that my wife was a captain with the Los Angeles Police Department at the time. And I recollect that she was at Internal Affairs when this case was assigned to me back in July of last year. At that time, she was the captain 2 there and the chief investigator. When this matter of leaks came up, the Los Angeles Police Department conducted its investigation, and essentially Captain York was not involved in that investigation. This issue has arisen again, and since that time my wife has been promoted to the Captain 3 of Internal Affairs, and I feel that since this particular motion involves files that are there, investigation that was conducted by the Internal Affairs Division of Los Angeles Police Department, I think it's more appropriate that another judge hear this motion. And I am comfortable with the fact that my wife has had no involvement in that investigation from start to finish, and I don't feel that there is any actual conflict involved. However, I think the appearance is such that I would feel more comfortable, and I think the parties would feel more comfortable if another magistrate heard this particular motion. And I discussed this informally with counsel off the record, advised them of my inclination that I was going to transfer this to another judge, to Department 100, to the supervising judge, Judge Basque, for his assignment, so that this can be heard by a magistrate who has no spousal connection to any of the parties involved here. However, I've also informally discussed with the parties that in the event that the magistrate hearing the motion does grant an in-camera hearing, that because this court is more familiar with the issues involved, that this court would then, with the agreement of the parties and stipulation of the defendant, agree to do the in-camera hearing if that comes to pass. Is that your understanding, Mr. Darden?
That is, Your Honor.
All right, is that your understanding, Mr. Walsh?
Certainly, Your Honor.
Is that your understanding, Mr. Cochran?
Yes, it is, Your Honor. And I prefer with Mr. Simpson regarding that.
All right, is this arrangement agreeable to you, Mr. Simpson?
And I should point out, Mr. Simpson does want to be present at that hearing when it's argued, Your Honor.
Yes.
And I had suggested to the court that if another magistrate wanted to come here, it would be fine, but we'll go wherever.
Well, let me ask, it's a matter of judicial protocol. I will invite Department 100 to make the assignment. Is it agreeable with you that I contact Judge Basque and ask him to make the assignment directly?
Yes, and then moving further, and I'll make a specific request, Your Honor, just from the standpoint of logistics, and we're set up here, we would like Mr. Simpson to be present for this hearing, and I would have, you have no concerns about protocol if the new magistrate would come
Just
here.
as long as they don't change all the adjustments on my
On your
chair.
chair. Or move your pins or your things. I understand, Your Honor. If you can work those things out, we'd be more than happy to remain here and wait for the other magistrate. And we could then, of course, in the course of argument, explain that if the magistrate believes that there should be an in-camera proceeding, we would stipulate both sides that Your Honor would conduct that because of your familiarity with the facts.
All right, then I'll take a brief recess, then I'll contact Judge Basque, ask him if he will assign the judge directly to hear the matter here. All right. All right, we'll take 5 minutes. Back on the record in the Simpson matter, counsel, I've consulted with Judge Basque in Department 100. He has agreed that for logistical reasons that he will assign the matter to Department 123, which will be heard here in Department 103 forthwith. So as soon as Judge Reed arrives, the matter will be heard. So I will excuse myself, and Judge Reed will take the bench to hear the motion. All right, we'll stand at recess until Judge Reed arrives. Thank you, Judge. Yes, sure.
All right, good afternoon. Needless to say, I am not at all familiar with the proceedings which I will now preside over, but for I have read and considered a defendant's motion for statements given a witness in the course of an internal affairs investigation filed August 1st, and a motion by the city attorney on behalf of the Los Angeles Police Department to quash defendant's motion, to quash the defendant's subpoena ducis tecum, which I have not seen. So other than that, I have read and considered nothing. Who on behalf of Mr. Simpson will be addressing the issues before this judge? All right, thank you, Mr. Ullman. And on behalf of the police department?
Arthur Walsh, Assistant City Attorney, Your Honor. Would you like me to give the court a copy of the subpoena ducis tecum at this point?
That would be helpful. And as that's being given to me, Mr. Ullman, in your motion filed August the 1st, it appears not to be in response to the SDT, but rather a request for discovery?
Yes, Your Honor. I believe the subpoena has actually been mooted. We believe we're entitled to this in the course of discovery in this case, and that a subpoena is not actually necessary, since what we are proceeding with is not a Pitchess motion, and I'll explain that at greater length, Your Honor.
No, I agree with you. That was my interpretation.
I think it's important at the outset that we get past any question of label. This is not a Pitchess motion. We are not seeking the personnel records of any specified police officer to show previous citizen complaints against that officer. What we are seeking is an investigative report that was done in connection with this very case to investigate issues raised by this case. And we believe that when witnesses are going to be called in this case to testify about those same events, that we are entitled, as a matter of course, to the statements that they made in the course of that investigation. I think the closest analogy that we have seen previously in this case is the investigation that was conducted on behalf of the Police Commission by Detective Muldorfer with respect to the events that took place at Vertel's garage with regard to the Bronco. Here we had a separate internal investigation by the police department in which Detective Muldorfer went to the garage and interviewed a number of witnesses who became material witnesses in this very case with respect to the same events, with respect to the chain of custody of the Bronco automobile. And of course that report was at that time produced and made available, and the previous statements that those witnesses had made to Detective Muldorfer were then available to both sides to confront and cross-examine and examine these witnesses with respect to those same events. Here, it's really just a matter of fortuity that this investigation was assigned to internal affairs. And simply by the administrative machinery of putting internal affairs in charge of this investigation, that does not insulate it from any discovery in a criminal case. The privilege that's created by Penal Code Section 832.5 with respect to personnel records is a qualified privilege for personnel records. It is not a qualified privilege for internal affairs investigations. And if those internal affairs investigations relate directly to the ongoing disputes raised in the context of a criminal trial, we believe that those reports and the interviews of the witnesses involved should be available to both sides so that they can properly litigate the issues that are raised in this case. Now, this is not a fishing expedition. We're not looking for an internal affairs report so that we can fish through it and see whatever we might find that may be helpful.
Well, let me stop you for my clarity. Your request is for statements made during this investigation.
Precisely.
It is limited merely to statements of potential witnesses or witnesses that will testify in this case.
That is correct. We are not seeking conclusions. We are not seeking recommendations. We are not seeking any personnel action recommended with respect to any particular officer. We are looking for the statements of witnesses, because those witnesses are material in this trial with respect to the same issues that were being investigated by internal affairs. We're talking about witnesses who will testify in this trial before the jury, notably Michelle Kessler, who is the director of the laboratory, then Commander, now Deputy Chief David Gascon, and their testimony will relate directly to the subject of the investigation by Internal Affairs, that is, leaks to the press, and also Mr. Matheson. So we believe that these
Who is
statements...
Mr. Matheson?
Mr. Matheson is a deputy director of the laboratory. And all of these people were, of course, the focus of the Internal Affairs investigation into where the leaks were coming from of testing results in the course of the investigation and preparation for trial of this case. The issue is also relevant in the context of the... Oh, I'm sorry. I've just been reminded that Aaron Riley and Colin Yamauchi, who are also employees of the laboratory, may have been interviewed in the course of this investigation. This investigation is also relevant in the context of the pending matter before Judge Ito with respect to piercing the shield law, because one of the factors that the court is required to look at in determining whether the newsman's or newsperson's shield law should be pierced is whether there are alternative sources available to get the same information. And to the extent that these witnesses were interviewed with respect to their knowledge of leaks, we do have the exhaustion of an alternative source, which may be a very compelling argument in favor of piercing the newsperson's shield law, because now we are left with only the newspersons as the source of information about where these leaks came from. And finally, they're relevant in terms of any potential exculpatory material, because the question of leaks has become a substantive issue in the context of this trial. We believe that any information that reveals the possibility of leaks within the Los Angeles Police Department may be exculpatory evidence that the defendant is entitled to under Brady versus Maryland. So for all of these reasons, we
Well,
believe...
what type of, I mean, unless you have some theory of an exculpatory statement, then in that sense it would be a fishing expedition. What are you looking specifically for?
We are looking specifically for information as to who had access to the information that was leaked, when they had it. We believe that the investigation may disclose a chain of events that points a inference or a circumstantial a suggestion with respect to particular individuals who may have been the source of the leak. And we believe that that would come within the Brady rule in terms of being potentially exculpatory evidence to show that, in fact, these leaks did come from the Los Angeles Police Department. Now, for all of these reasons, the report, we believe, is relevant to issues that we are litigating in this trial. But we're not even asking that the report simply be turned over to the defense. All that we're asking is that Judge Ito be allowed to conduct an in-camera inspection of the report to see whether there is relevant and material evidence that should be made available to the defense contained within that report. And under Section 915 of the Evidence Code, whatever privileged information may be in that report can continue to be protected. And again, I emphasize that we're not asking for privileged personnel files. We are asking for actual witness statements that are a result of this investigation. Even the shield of personnel records, however, is not an impenetrable shield. Like any other shield...
But we're not talking about personal
Well,
records.
we're not.
But I don't want to get off into something that is not pertaining to your request.
All I want to emphasize, Your Honor, is that the bottom line here is the defendant's right to a fair trial and accommodating that right while still respecting whatever privileges may pertain with respect to any of this information. And we believe that this issue is such an important issue to be litigated in this trial that to withhold from the defense an investigation conducted by the Los Angeles Police Department into the very allegations and issues that we are litigating involving interviews of the very same witnesses whom we are calling as witnesses in this trial gives us a right of access to those interviews. Could I have just a moment?
Yes.
I realize I have been making an assumption that Your Honor is fully familiar with the relevance and materiality of the leaking issue in this case, and perhaps I should take a moment to make sure that Your Honor is aware of the context in which this issue arises.
Okay, be somewhat brief. I believe that I am. I understand what you're asking for and the reasons you're asking for it. My concern is apparently you interchange the report, assuming there is a report, with any statements made by one of these 4 or 5 witnesses or potential witnesses. And my concern is, or at least my understanding of your request, is only previous statements, if they were made by one of these 5 people to the LAPD Internal Affairs in regards to the issue which you present, and that is the leaking of information to the press.
Well, let me clarify that, Your Honor. We believe the entire report should be turned over to Judge Ito for an in-camera inspection. We don't claim that we're entitled to see the entire report. Judge Ito can then glean from the report whether there are specific witness statements that relate to witnesses that are relevant to these proceedings, and at the same time, he can ascertain whether there is Brady material contained in the report. I don't know that. I'm kind of flying blind, but we would like the in-camera inspection to address both of those issues. And we believe it could also inform Judge Ito's resolution of the newsperson's shield law as well, in terms of providing him with a factual basis for a finding that there is no reasonable alternative to piercing the newsperson's shield law. So we think it's relevant for all of those purposes, but we recognize that we're entitled, at least initially, to the witness statements, and beyond that, we will rely on the in-camera inspection. Now, the relevance of the leak, of course, is the fact that this leak occurred before DNA results had been obtained, and in the case of one leak, the leak occurred very shortly after DNA results had been faxed to the LAPD laboratory. And from the standpoint of the defense being presented in this case with respect to the motive of the Los Angeles Police Department in terms of a motive to plant evidence, in respect to the integrity with which the evidence was handled, the fact that a leak emanated from the Los Angeles Police Department about DNA results before a DNA test had even been conducted evidences a good deal of confidence about those results that we believe would be informative for the jury in terms of resolving the issues that are directly presented by the defense in this case.
All right, that's pretty much covered, I think, in your motion filed August 1. All right, thank you, Mr. Holman. Mr. Walsh, you would like to respond?
Thank you, Your Honor. I have, I guess, a three-part argument that I want to formulate. The first has to do with clarifying what it is that the defense is seeking here. Dean Ullman suggested that this is not a Pitchess motion, and you tended to be said to agree. We use a lot of shorthand in criminal law, and I think the phrase Pitchess motion certainly is one of those shorthand phrases. The statutory scheme goes beyond a request for personnel records, which we most frequently see in police abuse cases or wrongful arrest cases. Penal Code Section 832.7 defines 2 types of records which are confidential. The first type of records are police personnel records. These are further defined in Penal Code Section 832.8. The second type of record, however, that Section 832.7 talks about are records of complaints maintained pursuant to Penal Code Section 832.5.
Which are citizens' complaints.
Well, these are complaints that the department has investigated. I don't think, I understand that the statute uses the word citizens, Your Honor, but I don't think the word citizens should be viewed as anything more than a descriptive word. I don't think it is intended by the legislature to have a limiting meaning.
Are you suggesting that if there wasn't internal investigations, that it was based upon some outside party or an internal request from the Los Angeles Police Department to investigate the accusations that were made?
I suggest that it doesn't make any difference, Your Honor, because initially the legislature commands police departments to set up mechanisms for receiving and investigating citizen complaints. And that's Penal Code Section 832.5. I don't know what the legislature had in mind when they used the word citizen. I'm quite clear, for one thing, that they didn't mean to preclude the non-citizen aliens from being able to have their complaints about police misconduct heard.
No, but I think it is clear, at least in my reading, that is a complaint made by somebody outside of the police department.
Well, The reason why I don't agree with that, Your Honor, is that the legislature, in enacting Section 832.5, was attempting to deal with the issue which had arisen previously and which was addressed in the Pitchess decision regarding police department destruction of records of investigations. And they were attempting to balance the need of the police department to maintain some confidentiality in its records with the public's need to have access upon a sufficient showing. And I do not think that that difference turns on whether the investigation stemmed from a complaint made by an insider or a complaint made by an outsider, because the social importance of having the confidentiality of those reports and at the same time granting access upon a sufficient showing is identical, whether it be an outsider complaining about police misconduct or an insider complaining about police misconduct. I have been representing internal affairs for many years, and I can represent to the court that a great number of complaints regarding police misconduct originate from police officers. As a matter of fact, Los Angeles police officers are under an affirmative duty to report to their superiors any instances of misconduct or abuse which they see. And these are then investigated pursuant to the methods that the police department set up under the direction of the legislature in Section 832.5. When the legislature said in Section 832.7 that those documents were confidential, I think they had in mind that they were protecting the interests of the police department in maintaining confidentiality of any type of internal investigation of misconduct. And I think that's what the analysis should turn upon. When the Los Angeles Police Department established its procedures, it decided to include complaints, whatever their source, in this same general umbrella of coverage that's set forth in the declaration submitted by the police department by Commander Davis. The police department has traditionally insisted that these records be considered under the rubric of Evidence Code Section 1043. This is not a particularly onerous demand to place upon criminal defendants or plaintiffs in civil suits. All that is required to obtain exactly the result that Dean Ullman is asking for is that they complied with the procedural requirements of Section 1043, a noticed motion, a declaration laying out materiality, identification of the officers whose records are being sought, and then leave it to the judge to make a determination of whether the materiality has been met and whether the other procedures have been met. I don't know whether they can do that. I've heard Dean Ullman express statements today as to why these matters are material. They were never incorporated in any sort of affidavit. The affidavit that was submitted with the subpoena duces taken is certainly insufficient to justify intrusion into confidential records. It's merely a boilerplate statement. I don't think that it's asking too much of this team of highly experienced and competent defense attorneys to simply comply with the legislature's directive. These documents are privileged. Now, the second part of my argument really is derivative of the first. I'm not clear what it is that the defense is requesting. I was given the subpoena duces taken for the internal affairs report, and I responded to that in my motion to quash. I'm aware that there was a motion filed with the prosecution. A copy was handed to me, but it was not served to the police department, and certainly not directed at the police department. Dean Ullman today said that the SDT is basically mooted out, and yet his concluding statements, he suggested that nonetheless he thinks that report should go before Judge Ito for an in-camera review. Frankly, I don't care whether Judge Ito reviews some or all of the report. My clients, however, believe that the defendant should be held to the letter of the law. If they want to review these, they should meet the requirements set up by the legislature for reviewing confidential documents. They have done it in the past. There have been many other motions before this court, decided by this court, in which the defense has done precisely that. We have reviewed peace officer personnel records. We have reviewed, by means of the Pitchess motion, an investigation into allegations that one of the witnesses in the lawsuit, in the prosecution, a police officer, had made references to the deceased that suggested that he had more knowledge of her than he would in the normal course of affairs. All of these were done under the rubric of Pitchess and under the guidance of Section 1043. I don't understand why we have deviated from that at this point, and I would ask the court to rule that the defense should meet the 1043 procedural requirements.
Which, of course, one of which is a 15-day notice, which means we delay the proceedings.
The last time we were in here, Your Honor, in February, I was willing to waive that, and we got the motion in 2 days. I'm not trying to make this trial last any longer than it's already lasted, but I haven't seen a declaration of materiality that I could address to decide whether the confidentiality of these records should be overcome. I don't understand, perhaps because I'm not fully a part of this trial, but only a very peripheral member, what the materiality is between the mere suggestion that a Los Angeles police employee is responsible for leaking information to the press in any relevant issue in this. It may very well be there, but it's not something that's clear to me, and I can't stand here and argue it without having it laid out for me. My clients are entitled to have a lawyer who can address these issues, and I can't do that. I don't understand how it is that the defense sees this as a relevant matter. In terms of the potentially exculpatory nature of anything contained in this report. The police department is certainly aware of its constitutional obligation to disclose exculpatory information to the prosecution so that it can be turned over to the defense, and the police department has never hesitated to do that. I'm not making any representation about what is or is not in the report, but that's really not at issue. This is not a motion to obtain potentially exculpatory evidence, and it doesn't come into play. The bottom line, Dean Ullman said, is the defendant's right to a fair trial. Fairness is the process that we're looking for here, but that fairness applies equally well to the police officers and other department personnel whose records are being sought as part of this internal investigation. And I would ask the court to require the defense to comply with the requirements of the statute. Thank you.
I'm not going to let you get away from the microphone that quick. So in essence, what you're saying is if they conform with what you believe the requirements of the penal code and the evidence code, then you will comply by bringing those records in for an in-camera review if it falls within 1043 and 1045 of the evidence code.
I'm not trying to say I won't comply at all. I have the custodian of records here right now if it's ordered that we have an in-camera review. But my point is that this is a two-step process. And the first step is that the judge is required to make a determination of materiality based upon an affidavit. And I'm entitled to challenge that once I've seen it. I haven't seen that yet.
Okay, that's assuming that it falls within the 832.5 and .7 penal code sections, that it is a citizen's complaint, and we can argue and debate whether or not this is a citizen's complaint, and whether then procedurally we have to go through what is required under 1043.
Well, I'm over here in response to the subpoena ducis tecum, as is the custodian of records, and that's basically all that I'm addressing. And that subpoena is clearly seeking the very type of report that's identified by Section 832.5. There is also a motion that's in front of you directed to the prosecution, asking them to produce records which they don't have, and which, if they were to ask the police department to provide to them, very likely the police department would say, no, that would be backdooring the requirements of Evidence Code Section 1043. Tell the defense to make a pitches motion. And I do not feel that the police department was properly put on notice that this motion was addressed to them by it being handed to me in court. It's not addressed to the police department, it's addressed to the prosecution. The police department relies on the provisions of Section 1043, which says they are entitled to separate notice. They haven't received that notice. But I'm not trying to stonewall anyone. I think it's important that these arguments be made and that the law be adhered to. If you decide otherwise, as I said, I have these records here. We are ready for an in-camera review. But I do not think it should be called for on the record before this court.
All right, thank you. All right, Mr. Ullman?
Very briefly, Your Honor, I don't think there's much question, but that the substance of everything that 1043 requires is in our moving papers. What is missing, however, is the identification of any particular officer, because that's not what we are seeking. And I think that goes to the heart of why what we're pursuing is not a pitches motion. A pitches motion is directed to personnel records of a particular named officer. Now, we could put a list together, and if we want to play guessing games, of every officer we think that Internal Affairs might have talked to in the course of this investigation.
Let me stop you there, unless I misinterpreted what Mr. Walsh has said. He's not arguing that point. The point he's arguing, technically you have not conformed with 1043 and its requirements, but specifically it's the materiality of the subject matter that you have requested. And 1043 does require an affidavit, which is not before me. It is merely a motion, and I don't stand on form over substance. If it was given to the district attorney, I presume that he passed it on to Mr. Walsh. If that's incorrect, please inform me.
No, I was given a copy of it by the defense.
All right. By the defense?
By the defense.
All right, so, it may not be technically the appropriate notice, but at least you were so informed. The question then becomes, is it material?
Well,
And have you reached that threshold to where then Judge Ito should have an in-camera hearing to determine what should or should not be turned over?
Well, the materiality is established by the very nature of the investigation that was being conducted. It was an investigation into the source of leaks of information in this very case. In fact, Your Honor was inquiring whether this was a citizen complaint. The complainant was the judge presiding in this trial. It was Judge Ito who initiated the request for some sort of internal investigation by the LAPD as to where these leaks were coming from in frustration, experienced by all of the counsel in this case of picking up the morning newspaper and reading about lab results that we hadn't even seen yet. And Judge Ito took the extraordinary step of ordering that all of those results should no longer go to the Los Angeles Police Department. They should come directly to the court and then be distributed to counsel. So this is not a personnel complaint with respect to any individual officer of the Los Angeles Police Department. It is an investigation into circumstances that relate directly to this case and to issues that we are litigating in this case.
That's the question. What is the material issue? The fact that Judge Ito was frustrated because things were being reported at a time, at least as I recall, a time that the jury was attempting to be selected, obviously is quite frustrating. And I'm sure that's the reason he asked for the investigation. But as to it being a material issue that is being presented to the trier of fact or before this court, that is the issue of materiality.
Okay. Well, it becomes a material issue in the context of the defense being presented in this case that evidence was compromised in the way that it was handled by the Los Angeles Police Department. And the fact that officers of the Los Angeles Police Department were leaking test results before the tests had even been conducted is highly material in terms of the trier of fact resolving that issue with respect to the integrity of the handling of the evidence in this case. So it goes directly to the whole chain of custody issue, to the issue of whether there was possible tampering with the evidence, to the issue of the motivation of the Los Angeles Police Department and the way it conducted the investigation of this case. Those are the issues we are litigating in this defense, and we're calling the same witnesses, we believe, that were interviewed. And of course, we don't know that. We haven't seen the report, but we believe, and we have testimony already from Michelle Kessler in a 402 hearing conducted by Judge Ito that she was interviewed by officers of the Internal Affairs Division in the course of an internal investigation. So we know this investigation took place. We know of at least one witness who was questioned. There may be others. I believe Matheson also testified that he had spoken to officers. So it is not seeking personnel records. It is seeking an internal affairs investigation. And I think where we part company, essentially, is that they are reading the statutes and the evidence code sections as some sort of privilege for internal affairs investigations. And that's not what the statute or the evidence code provisions are talking about. They're talking about the protection of personnel records with respect to citizen complaints. We're talking about something else, and we don't believe that the privilege created by the statute or the evidence code extends to any broad shield that can be erected around anything that internal affairs does, regardless of its materiality or relevance to an ongoing criminal prosecution.
All right. Mr. Darden, I see you either getting antsy or you want to address the court.
Both, Your Honor.
All right.
Good afternoon, sir. Your Honor, with the court here from Deputy DA Hank Goldberg on the issue of whether or not the information sought is relevant and material.
Yes? Mr. Goldberg?
Thank you, Your Honor.
Good afternoon.
I wanted to primarily address the issue of materiality, Your Honor, but before I got into that, I just wanted to say a few words about the appropriate discovery vehicle that's previously been discussed by counsel.
Well, let me stop you. And I seem to think that we keep getting off the track, or I don't understand where we're going. Mr. Walsh led me to believe that the issue really before me is it material. If it is material, then he will, in essence, forego some of the other formalities of discovery, since he's prepared to address that if the court allows an in-camera hearing. Mr. Ullman says it's material because the judge requested it and it pertains to the defense. We all get back to the same issue, at least as my understanding. Is it material to the sense that the court should grant an in-camera hearing to determine whether there is discoverable statements made by a potential witness in this case, which should be used in preparing examination of that witness?
I agree with the court. That does seem to be the primary issue, but if I understood what Mr. Walsh said, and I'm sure he'll correct me if I'm wrong, one of the reasons that he wants compliance with the so-called pitches procedures is that he would like a declaration from the defense so that he could determine whether or not it was material and fully understand what their argument is or what their facts are to support the allegation that this does have some materiality.
Is this the same issue that's presented to Judge Ito in the shield, the reporter's shield, as to whether it's material, to whether or not that shield should be pierced for the benefit of the defendant's right to a fair trial, as weighed against the reporter's right to protect sources?
Yes, Your Honor. And
so are you not asking me, or all of you not asking me, the decision that he has to make in that particular
well, that's
decision?
what I think, Your Honor. And there's also a third context in which it comes up, and that's the people have filed a motion to preclude the defense from cross-examining Michelle Kessler about the subjects of the leaks. And the grounds that we've stated in precluding that cross-examination is lack of materiality. So it actually has three potential impacts in this trial. And in all due respect to the court, that's why I was a little bit confused as to how the court could decide the issue of materiality, given that that really is at the center of three distinct issues that are before Judge Ito, and plays a key role in terms of the overall issues in this case and what is or is not at issue in this case. So I don't know how Your Honor wants to deal with that problem.
Well, I'm somewhat disadvantaged. I don't know all the facts and the circumstances that have been presented nor the previous arguments. If we are down to that issue, and if everybody agrees that that issue is before Judge Ito, at least in two other circumstances, then I am prepared to allow him to make the decision as to whether or not it is material. If it then is material, if he rules that the subject is relevant, it is a material issue that should be presented, then I assume, strike that, then it would be the court's intended order to allow an in-camera review of the internal investigations reports dealing with witnesses' statements. If he rules it is not material, then this all becomes moot, and the intended ruling of this court is that it would not be discoverable. Now, Mr. Walsh, you want to respond?
I want to briefly agree with what Mr. Goldberg said and clarify the police department's position. We do believe that the basic issue is materiality. I don't know whether it's the same question of materiality involved in the reporter's shield law, involved in the prosecution motion that Mr. Goldberg referred to, but the question is materiality. However, the police department wants to insist on its 1043 right to have that materiality laid out in a declaration, an affidavit, not by representations of counsel.
All right, let me stop you there, Mr. Ullman. I think they are technically have a right to have that affidavit or declaration. When can that be prepared and served upon Mr. Walsh or the LA Police Department?
We can take the material that's in our moving papers and put it in a declaration and file it tomorrow. But again, that is assuming that this motion is governed by the pitches requirements. I think Your Honor's on the right track with respect to the determination of materiality. In fact, Section 1045 of the Evidence Code, which honors the right of the defendant to material that is relevant to the subject matter in the pending litigation, provides that in determining relevance, the court shall examine the information in chambers in conformity with Section 915. So what's initially required to get production of the report is simply a prima facie showing of materiality, like in a discovery motion, that it has potential relevance. And then once it's produced, the court makes that determination in the course of its in-camera inspection. There's certainly more than enough to show the prima facie materiality in our moving papers, and we can put that in declaration form, although we don't believe that's required because it's not a pitches motion.
Well, form, once again, I think it's form over substance, but I'm going to require that of the defense to present that to Mr. Walsh or a representative of the Los Angeles Police Department. I think the court always has to determine whether something is material before it should be turned over by way of discovery, whether or not it falls within the four corners of 1043 and 1045 and the other sections that we have previously mentioned. I think at that point, when Judge Ito has an opportunity to review...
Did Ito get his hair cut? What's going on? Why is there a different judge? I didn't get to hear it while I was driving. I don't have data right now. So I couldn't take you with me. What is going on? Bryden, it's nice to see you again. It's been a while. Has this been doing that the whole time? Like, spinning?
The affidavit or declaration, then I think it would be appropriate, because he's far more familiar than I, to make the determination as to whether or not it's material. And if necessary, I will then, based upon his decision, make a ruling whether or not there should be an in-camera proceedings, for which I understand all parties have agreed that he will hold. He will review whatever is available and then make the decision as to what is discoverable or not. I will only make the order if he makes a determination it's material. Now, does anybody want to add anything at this point, or we'll leave it at that?
Okay, I get you, Bobby. That was my bad. I thought it was a different judge entirely. But of course they wouldn't switch out judges in the middle of the O.J. Simpson
Good afternoon, Your
trial.
Honor.
That would be
In that
stupid.
regard, Your Honor, it's a scheduling matter. We certainly appreciate what Your Honor's indicated. We seem to be on the right track here. We can certainly have that declaration tomorrow morning. As a matter of importance, however, we're at that stage in the trial where these may be very well be the next witnesses. I've represented to Judge Ito this afternoon that we need a ruling on this along with some other motions he's working on that will also be important. We don't have other witnesses at this point in the trial, so we need to get this done and need your availability perhaps tomorrow morning because we want to resolve this, get this to Judge Ito. He can make his judgment regarding materiality. If you then rule or make an order, he can then review the documents and then make a determination because these will be our next witnesses. We need time to look at those reports before calling those individuals.
All right, well, I'm available anytime after 7 tomorrow morning. I think you need to make some arrangements with Mr. Walsh and Mr. Darden and whoever else, what time those will be presented, and then present it also to Judge Ito and give him the opportunity to review them.
I think we're also entitled to.
True, Nan, true. What is going on with YouTube today?
Fair point.
This happened during my stream, too.
Well, Mr. Walsh, I understand your position, but I suspect this is not coming totally as a surprise to you.
Nor is it coming totally as a surprise to the defense either, Your Honor. They've had I believe 10 months to prepare this motion. They've had 6 days since I filed my motion to quash the SDT where I put them on notice that I was claiming that this was covered by the provisions of Section 1043. They're waiting until this afternoon, and now they're saying, gee, they have to have an expedited ruling on it. I think that the police department is entitled to have its opportunity to be heard in this matter. The legislature has set out the procedures. I'm not insisting on 15 days, but I don't want a 5-minute or 2-hour turnaround.
All right, what time, Mr. Cochran, will you have that declaration before the court?
I'm sure we can have it here by 8:30 tomorrow morning. And we would expedite it, and we certainly aren't dragging our feet because, you know, Mr.
No,
you understand.
let's not make
Right.
accusations. It
Okay.
accomplishes nothing. Let's
Fine.
try to expedite it,
8:30?
giving both sides an opportunity to a full hearing and to litigate the issues. You'll have it by 8:30. Is there a time set tomorrow for the return of the jury?
We've not reached, I think the jury may still be somewhere upstairs now, I believe, Your Honor. They've not been released yet, so the court still can do that. We perhaps need to speak with Judge Ito after this is over, all parties.
All right, why don't we stand in recess at this particular time. Let me have an opportunity to confer with Judge Ito, and then if necessary with counsel in regards to when we can have an opportunity for not only Mr. Walsh, but for he to review the declaration and make a determination, and if necessary, hear from counsel. And I will make myself available tomorrow at any time so we can hopefully resolve this to everybody's satisfaction. All right, let's stand in recess then.
You know, it would have been so much better if we had
All right,
this
back on the
judge
record. I
yesterday.
understand we need to settle some scheduling.
I'm so mad. I'm so mad because fake Kathy was here yesterday. And real Judge Ito was here yesterday. And now we have real Kathy here and fake Judge Ito. And we were 1 day off out of the whole trial. Those 2 days could have lined up perfectly. And there's Josh.
Scheduling matters. Counsel.
Yes, Your Honor. May I address for a minute?
Yes.
Just briefly, as I understand it, Judge Reed has listened to the arguments of counsel and has basically concluded that if the defense were to proffer a declaration regarding materiality, which I've represented, we would have here tomorrow at 8:30, he would then ask that Your Honor consider this declaration of materiality. He would then, if you found it material, which we trust you will, he would then make an order turning over certain reports conducted by Internal Affairs. And we were then in a kind of a scheduling quandary. I indicated to him that, as I told you, these are our next witnesses. We need to get an idea of scheduling. We're all available, but we need time to go through the reports, synthesize them, and then get ready for the next witnesses. And the court is aware who those witnesses are.
You know, this actually compounds the issues regarding the...
Whatever you do, don't say AI Kathy in front of Zach. You know how he feels about that AI garbage they put on YouTube right now. It really is garbage, though. It just, the videos are so bad. And they get so many views. They're so popular, and I don't understand it.
Bosco
Yes.
issue.
And that's the other part.
Because, I mean, this broadens the scope of alternative sources, which is really where we're going
Yes.
with all of this. So you're saying that I need to make an initial finding of materiality first
We think so.
before I even get to the balancing test, the other balancing tests that are suggested in Delaney. Is that,
I think it's the threshold finding, really, Your Honor, that Judge Reed, I mean, we would all agree you're in a better position than Judge Reed being at a disadvantage. We need to make that particular finding. This issue can somewhat stand on its own, but we wanted, as Mr. Allman indicated to you, we think this issue should proceed before your other issues because it will assist you, hopefully.
yeah, I see the point.
Judge, you
All right.
I think where we're at is a threshold determination of materiality needs to be based on this declaration, but the issue of relevancy is part of the in-camera review under Section 1045. So all we're talking about is kind of a prima facie showing of materiality at
So,
this point to get the.
There are two types of people who fall at my job, who I help. There are two types of people. Ones I never see or hear from again, and the others who come a year later and give me flowers. So I don't know yet which one she is. I really hope I get an update, but I doubt it. They live in York, which is, 45 minutes away, depending on where they live. So it's not like they're always in Lancaster where I am to see me. And the place that I work at, you don't get regulars. You get people who come once a year on like a birthday, but they don't come every Tuesday or anything like that. So I probably won't ever get an update unless, we get sued.
The records turned over.
Because
At that point, Your Honor reviews them.
helped.
We believe that review can encompass a determination of whether there are witness statements that the defense is entitled to, whether there is Brady material in the report, and whether this alternative source has been exhausted in terms of the newsperson's shield law determination that Your Honor has also considered.
All right. Mr. Walsh?
One question in terms of scheduling that was left unanswered is to what extent the city and the police department will have an opportunity to review the declaration and submit some sort of response regarding our view of its materiality.
How about if we do this? How about if I direct you and the representative of the defense handling this matter to be present here tomorrow morning at 8:30 to...
I have a conflict, Your Honor.
Okay.
I have a civil court appearance. I may be able to have a different attorney cover this or that, but at this moment I'll have to work that out. All right, why don't we, let's do the 8:30, and I'm not sure
8:30.
it will be me.
And then on the record at 9 o'clock, I'll allow you to make any representations or any argument in contravention to the declaration of materiality,
All right.
rather than require a written response. So I think that will expedite matters. And I will be prepared tomorrow morning at 9 o'clock after I hear the arguments to rule on whether or not there's been a prima facie showing of materiality.
And would you then do the in-camera if you made that determination?
Yes.
So I would have the
Yes.
custodian present for that. Very well.
Have them available within a short period of time, on call.
All right.
All right. Okay, what else do we have left?
Well, we have one other motion, but then that, based upon that, Your Honor, I suppose, just as a matter, could the court give me some inkling of then what Your Honor's pleasure is going to be regarding the ruling that may also follow this ruling, and because we'll know then better who our next witnesses are going to be, because that's the issue.
Well, here's the problem, Mr. Cochran. Once I make a finding of materiality, assuming that that occurs, then Delaney sets out 4 different criteria that I then have to contemplate and balance. I won't know what those criteria are unless and until I conduct the in-camera hearing with IAD, or if that avenue is foreclosed, then that becomes a moot issue, and then it's a different equation. Then, assuming we get past all of that, and let's assume that I issue an order directing Mr. Bosco to testify, then they're going to
Please,
request a
stop.
study.
You went
And
too
they've indicated
far,
that
that
they're going to
one.
challenge that.
Just broke my brain.
So, and it would be my preference to, allow them some time to take whatever appellate remedies that they have available to them. So my guess is that we ought to probably prepare to go forward with witnesses in the next day or two other than these people. Because let's assume that all the cards fall in your favor, and we do have, and I do require the news media people to testify, they are going to request stays and go to the Court of Appeal. And they won't be available till at the earliest the end of the week, or perhaps the beginning of next week.
All right, given that thought, Your Honor, we will then...
And the prosecution has all along said they're going to raise 352 objections to all of this, as
Judge, how dare you interrupt him like that? Please be quiet when he's talking. The court reporter can't get you both.
being speculative unless there is a very clear connection between this and that.
We think we can make that, but we
So-
will, out of an abundance of precaution,
So my suggestion to you is that you be prepared to go forward with witnesses other than this circle of witnesses.
by Thursday, is that what you're saying to me?
How about tomorrow?
Well, we have some work tomorrow morning, certainly.
How about tomorrow afternoon?
Let me see if, I hope we can do that.
It would thrill me to death if I had the morning to work on this
Well,
stuff.
that'll be fine. And as far as the jury, then let us then see where we are, and let's try to be ready tomorrow afternoon with some witnesses. We don't want to delay the trial, if at all possible. We'd like to go in the order we've talked about, but I understand the procedural problems. with
Even
that.
if I ruled in your favor today,
Yes.
we still wouldn't have live witnesses really available till next week, my guess. And Dean Allman's nodding that he thinks that's probably true.
We probably can, well, we'll work that out here. We'll try to have some witnesses for tomorrow afternoon, hopefully.
All right, and let
Are you guys getting ready for Christmas? I'm starting to get antsy and excited. Like, I want it to hurry and get here, and I want it to hurry and be over with and be behind me, so I don't have to think about it anymore. But it's starting to look and feel like Christmas everywhere.
let Mr. Darden and Ms. Clark know.
We can proceed with
All right, Mr. Walsh, thank you very much, sir. See you tomorrow morning.
Other than Dr. Bodden,
I assume the Christian Stockdale matter will resolve this afternoon. My recollection is that counsel contacted the court, or the court contacted counsel, and he and she are available this afternoon,
Good to know.
is my understanding. She's en route.
Okay, I heard she's gonna be here 2:30, that's why.
Well, she may be still stuck at the metal detector.
we would have an opportunity to confer with her, and we'll then proceed.
I'm assuming that we can resolve this without a full hearing once she's here.
I thought the court had wanted testimony to resolve it.
No, well, as I indicated to you, there's a factual dispute. One side says one thing, the other side says something else. If she's here, she can tell us one way or the other.
Right. I assume you want that in the blue chair, but
Well, if she comes in with a tape recording and says, here it is,
happy day. Okay.
you never know. All right, so my proposal is for this afternoon, then, that we release the jury, and that we stand in recess until the arrival of Ms. Stockdale and her counsel.
Maybe push one.
Sure.
It's been 3 days since I've fast forwarded a sidebar with you guys. Whew, it was hard. It was long, hard 3 days. Oh, and I didn't do it right. I forgot how to do it.
And her counsel, is that correct? All right, and who are the counsel appearing with Ms. Stockdale?
Tom Nolan and John Schuster.
All right, good afternoon, counsel. You want to state and spell your names for the court report, please?
Nolan, N-O-L-A-N.
And John Schuster, S-C-H-U-S-T-E-R.
All right, counsel, what we're here for is a discovery proceeding to determine the whereabouts, history, et cetera, of a certain telephone answering machine, tape recording. Have you conferred with your client?
We have, Your Honor. We also have conferred with both the District Attorney's Office and Defense Counsel and explained the situation, and Ms. Stockdale is prepared to testify this afternoon.
All right, then we'll proceed.
Thank you.
And counsel, if you feel it's necessary to consult with your client anytime during the examination, feel free to ask leave of the court for that purpose.
Thank you. We expect it not to be necessary.
All right.
Thank you.
Ms. Clark.
Thank you, Your Honor. People call Reverend Stockdale.
All right, Ms. Stockdale. All right, Ms. Stockdale, face the clerk, please.
Raise your right hand, please. You solemnly swear that the testimony you may give in this class now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you
Did anybody buy anybody Barbies for Christmas? I don't know why I'm thinking about Barbies right now, but I'm just wondering.
My name is Gretchen, Gretchen, Stockdale, Stockdale.
Ms. Clark.
Good afternoon, Ms. Stockdale.
Good afternoon, Ms.
Thanks
Clark.
for coming in.
Sure.
Were you acquainted with the defendant back in 1994, ma'am?
Yes.
And as of June 12, 1994, had you been dating him for some period of time?
No, I wouldn't characterize it as dating.
When had you met?
Oh, in 1988, casually at a charity event.
And then had you seen him again after that?
Yeah, we ran into each other several times over the years.
And at what point did you at some point begin a dating relationship?
Like I said, I wouldn't characterize our relationship as dating. We had a good communicative friendship. And in 1993, around the fall, I contacted him to actually ask his advice on an investment issue.
Okay, what kind of contact did you have? Did you ever meet for dinner?
Prior to,
Is irrelevant
Overruled.
for this issue.
Overruled.
could you be more specific? When,
Yes.
Are you?
Yes. Between 1988 and 1994, did you ever meet him for dinner?
No, actually, I.
Counsel, all I'm really interested in is the flavor, the nature of the relationship, so let's not go too far with this.
Okay.
All right.
All right. Were there any intimate dinners that you had? During
No.
the scope of time you saw each other?
No,
Did you ever see each other in person?
Yes, as I said, I ran into him several times on different occasions. NFL functions, charity events. I actually did run into him into a restaurant one time. And he was on a date with Paula, and I joined them briefly.
Okay. Then, at some point in the year of 1994, did that relationship become more intimate?
No.
Never at any point?
Well, yeah, I think our communication increased around 93, as I stated, around the time when I called and asked him for some advice.
And that was business advice?
Yes.
All right. And then did you continue to have regular phone conversations after that point in 1993?
Yes, I would say so.
And were those conversations all regarding business?
No.
They became more personal?
Yes, we developed a friendship.
And did you discuss with him the nature of his relationship with Paula Barbieri?
What's his name?
Okay. Did you discuss with him the nature of his relationship with Nicole Brown Simpson?
Overruled.
Yes, periodically.
Okay. And when did you begin to have those conversations concerning Nicole with the defendant?
Around the fall of 93.
And did you continue to have those conversations with him through 1994?
Yes.
When you had those conversations with him about Nicole, was that in person or on the telephone?
Both.
Okay. And when you had those conversations with him in person, where did they take place?
Oh, a number of different places. At his home, at my home, at a restaurant.
Okay. How many times would you say in the year of 1994 did you have conversations with him about Nicole in his home on Rockingham?
I'm not really sure. I couldn't give you a number.
Can you give me an estimate? Like
How many times we spoke about Nicole?
in 1994?
Specifically at his home?
Yeah.
Is that what you're asking me? Oh, 3 times.
Okay. And when in 1994 was it that you had those conversations about her in his home?
Counsel, I think our focus here is the tape, though. That's what we're interested in, correct?
Yes, ma'am.
All right.
All right. Can you tell us how many times you visited him in his home in 1994?
Counsel, let's move on to the tape.
Okay. By June the 12th, 1994, had you formed a more intimate relationship with him in terms of personal discussions and involvement?
In terms of communication, yes.
Okay. Had he made any overtures to you about becoming his girlfriend?
No.
Overruled. Answer will stand. Let's move on to the tape and the whereabouts of the tape, please.
All right. On June the 12th, 1994, at some point, did you leave your home?
Your Honor, may I suggest if she does not start asking about that damn tape that you sanction her? Just a suggestion.
Yes.
And did you come back and retrieve a message?
Not on the 12th, no.
Okay. When did you retrieve that message?
I retrieved a message on the 13th, but not from my home.
All right. Did you have an answering machine or a message service?
Yes, it's an answering service, a telephonic answering service.
Can you tell us how that works?
It's my voice on the machine, and you can leave a private message on that machine. Then I call in and enter a code and retrieve my messages.
Okay. Is that like voicemail?
Yes.
All right. And did you retrieve some voicemail on June the 13th?
Yes.
And was that message from the defendant?
Yes.
Did you have an accurate recording of the time on your voicemail?
It states the time on my voicemail, what time the message comes in.
Okay. And do you know, if you know, as of June the 12th, 1994, in the evening hours, was the timestamp on your voicemail accurate?
As far as I know, yes.
You had not made an independent check?
No.
All right. When you retrieved the message, did it indicate that the message from the defendant came in at 7:35 p.m. on the night of June the 12th?
Yes, it did.
And I'm going to read to you a quote from the New York Daily News. I'm going to ask you to tell me whether or not this seems to replicate the message that you recall being left for you, okay? On the night of June the 12th at 7:35 p.m., okay?
Okay.
quote, "Hey, Gretchen, sweetheart, it's Orenthal James, who is finally at a place in his life where he is like totally unattached with everybody. Ha ha. And in any event, I've got a Sunday evening. I guess I'm catching a red eye at midnight or something to Chicago, but I'll be back Monday night. If you leave me a message, leave it on 310 and then a number, and then that's 310 and then the number repeated again." Do you recall what I've just stated to you as being the message left for you by the defendant on the night of June the 12th, 1994?
I can't recall verbatim, but it appears close, yes.
It sounds right?
Yes.
If I showed you this and let you read it, would that help you to state whether or not this was an accurate rendition of the message you got?
You could show it to me, but again, I haven't heard it for quite some time, so I don't know if word for word is correct, but it's basically what I remember.
Okay. Okay, I'll let you look at it in a minute and see if that helps you anymore.
Okay.
But then you picked up that message on June the 13th, is that right?
That's correct.
From your voicemail?
Yes.
Did you preserve that message in some manner?
Yes, I did.
And how did you do that?
Just by pressing the number that indicates save on my machine.
And you saved the message on, was that a regular tape or a microcassette?
Well, I'm not sure what they have at the answering service. It's whatever they have in their building.
Okay.
I'm not sure how they use it. Maybe computer or disk.
Okay. Now, the statement that he makes in here, that he said he's finally in a place in his life where he's like totally unattached, and he said he'd love to, I guess I'm catching a red eye, I'd like to get together Monday night. Was this the first time that he had made such a statement to you about being free and available?
Objection irrelevant.
Sustain. I'm interested in where the tape is.
All right, you press the button save.
Yes.
Then what did you do? Did you ever retrieve that tape physically?
At a later date, I asked for a copy.
Okay. From your answering service?
Yes.
And they gave it to you?
They mailed it to me.
And was it a microcassette or a regular cassette?
It was on a regular size cassette.
Okay, and then when was it that you got that cassette physically in your possession?
That one I received on, I don't know, a week or so after the message was left.
So that would have been the 19th of
Or
June?
around there, 20th.
And when you got that cassette in your physical custody, what did you do with it?
Put it away.
In?
Just in my closet, I think.
Okay. At some point in time, did you have a conversation with a defense investigator by the name of William Pavlik?
Yes.
And when was it that you had that conversation with him?
It was sometime September, October, I can't remember clearly, of that year.
And do you recall having a conversation with a DA investigator by the name of Dana Thompson on June the 21st, 1995?
Yes.
And do you recall telling him that you turned over that tape to William Pavlik, the defense investigator, in September of 1994?
Yes.
And does that seem, to the best of your recollection at this time, an accurate time for when you gave Mr. Pavlik that tape?
Yes.
Okay. And then when you had the conversation with Mr. Pavlik, you at that time physically gave him possession of that tape?
Yes.
And did you tell him what was contained on the tape?
Yes.
Did he tell you what he intended to do with it?
Yes.
What did he tell you?
That he would take it and listen to it and pass it on to other members of the defense.
Did he tell you whether or not he intended to present it? They intended to present it in evidence.
At that time, he didn't say one way or the other what he planned to do with it.
At that time, did he tell you whether or not he thought that they would call you as a witness for the defense?
No, he didn't.
You had no conversation about that at all?
No,
I'm sorry?
we didn't.
Did you expect to be called as a witness for the defense?
No.
Okay. Did you expect
Are there any copies of this tape anywhere? Did you make any copies before you gave it to Mr. Pavlik?
Yes, there was another copy made.
All right, how did you do that?
I held up a cassette recorder to the telephone, the actual telephone.
And what happened to that copy?
That has been taped over.
When did you notice that it had been, when did you realize or discover that it had been taped over?
Oh, that's a lie.
Well, I didn't realize it. I did it several months ago.
All right, what is the name of the telephone answering company that provides the service for you?
Prestige voicemail.
And where are they located?
Lomita.
Ms. Clark, anything else?
Yes, thank you, Your Honor. Can you tell us, ma'am, how many times you visited Mr. Simpson in the jail?
Sustained.
Can you tell us how many times you visited the defendant in jail since June 21st, 1995?
Overruled.
I haven't.
You had no visits?
No.
Wait. Let's move on to something else.
Okay.
It has to do with the location of the tape, where it went, who's got it.
Do you
Was this
recall?
tape ever returned to you by Mr. Pavlik?
No, it wasn't.
All right.
Did you play the tape for Mr. Pavlik?
No, I didn't. He brought a tape recorder along, but it was a micro cassette, and as I stated, it was on a regular size tape recorder, so he took it with him.
Now, you were interviewed by a reporter for the New York Daily News, correct?
That's incorrect.
You were not interviewed?
No, I was never interviewed.
You did not have any conversation then with Michelle Caruso of the Daily News?
Absolutely not.
Did you ever play that tape recording for anyone?
No, I certainly did not.
You didn't play it for Michelle Caruso of the Daily News?
No.
Did you play it for any of your
Sanctions.
friends?
No, I didn't.
Did you play it for any members of the defense team?
I didn't personally play it. I don't know what Mr. Pavlik did, but I didn't.
What about why did you make the additional copy after you gave the first copy to Mr. Pavlik?
I didn't make it afterwards. I made it at the same time I requested the copy from the voicemail.
Okay, and why did you make that extra copy?
In case the one from the voicemail got lost or it didn't work or I didn't get it, I would still have one.
Okay, and you did not give that extra copy to Mr. Pavlik?
No.
Do you recall when you were interviewed with Dana Thompson of the DA's office on June 21st, 1995, do you recall telling him about that second copy, the copy you made yourself from the telephone?
No, he didn't ask me if there was a second copy.
Would you do me a favor, please, and review this statement here?
Okay.
That is a report of your conversation with Dana Thompson, and tell us if the information contained in that is accurate.
It's incorrect.
And in what respect is that?
The portion of the sentence that says, and gave him her only copy of the above tape. He just asked me if I gave a copy.
All right, and in this interview report, it states that you told him on June 21st, 1995, that you gave Mr. Pavlik the only copy of that tape in September of 1994. That's what it states here, is that correct?
That's what it states.
And your testimony now is that that's incorrect?
Correct, that's incorrect.
Okay. Now, do you also recall that you, through your lawyer, demanded a retraction of a portion of the story that was run in the New York Daily News concerning this tape?
Yes, that is why I initially retained legal counsel, is because I wanted formal papers filed demanding a retraction that I was trying to sell this tape. It's absolutely a false assertion.
Okay. And that portion of the article that asserted that you were trying to sell this tape was in fact retracted at your request, correct?
You bet it was.
Okay. And then, but the rest of the article, which details the quotation that I've read to you, you did not demand a retraction as to that, correct?
No, I didn't.
And I'm going to ask you to review what's highlighted here. It shows the date, the time, and the substance of the conversation that was recorded, and ask if that is correct and accurate to the best of your recollection.
It's close to what I remember.
And the court has already elicited the statement as to what the name of the service is?
You know, most of these voicemail systems are actually computer disks, digital.
That seems to be an accurate rendition to you?
Yeah, as I said, I don't remember word for word what it said.
And then is your testimony... Can you remember at this time who it was that you asked at your answering service, the name of the person you spoke to when you asked for the copy of the tape?
Yes.
Shall we say that? Can you tell us?
His name is Bruce Humiston.
Can you spell the last name?
I'm speculating Humiston.
Okay, well, we'll look for something close. When was it that it came to your attention that the other copy that you kept was no longer useful?
After I recorded over it.
And when did that happen?
Oh, several months ago, March, April.
March, April of this year?
Yes.
Okay. And when you were recording over it, did you know that you were recording over it?
Yes.
Okay. You intentionally did that?
Yes, it was no longer any importance to me.
Okay. Did you check with anyone on the defense team before you did that to make sure that it would be okay to erase it, basically?
No.
Okay. Did you inform anyone on the defense team that you had done so?
No. Not at the time I did it.
When was the first time you informed anyone that you had erased that other copy?
The first time I told anyone?
Yeah.
When the issue arose in the New York Daily News when I was speaking with my lawyers.
Okay. And that was back in May of 1995?
Yes.
May I have a moment, Your Honor?
Strawman?
Ms. Stockdale, the copy of the message that you made yourself, was that before or after you received the copy from your answering service?
Before I received the copy.
All right. So initially, you just held a tape recorder up to the telephone and made a copy yourself?
Yes.
All right. And then later, the answering service sent you another taped copy of the message?
That's correct.
All right. Now, do you recall which of those two you gave to Mr. Pavlik?
I believe it was the one I received from the voicemail service.
All right. And the one you kept then was the one that you had made yourself?
Yes.
Now, you didn't tell Mr. Pavlik when you gave him a tape cassette that it was your only copy of the message, did you?
No, I didn't tell him it was my only copy.
And when you were interviewed by the district attorney in June of this year, you did not tell them that you gave Mr. Pavlik your only copy?
No, I didn't.
All right. Now, you gave the copy of the tape to Mr. Pavlik in September?
That's the best, to the best of my recollection. That's what
And
I
the
meant.
best of your recollection is that the copy that you kept was not erased until...
I know that they are about to play some really bad tapes. I don't know if this is the exact tape they're talking about or if this is a different tape.
March or April?
Yes.
So then after you gave Mr. Pavlik a copy, you still had a copy for approximately 5 months?
Yes.
Now, did Mr. Pavlik at some time call and inform you that you were not going to be called as a witness by the defense?
Yes, he did.
Was that before or after you taped over your copy?
That was before that was sometime before I,
All right, so you were aware then, when you taped over it in March or April, that the defense had decided not to call you as a witness?
that's correct.
And did you ever request that Mr. Pavlik return the copy of the tape that you had given to him?
No, I didn't.
Nothing further.
Ms. Clark?
In September, when you first met with Mr. Pavlik and gave him this tape, did you discuss the subject of how many copies there were with him?
I can't recall.
Do you recall him asking you if that was the only copy?
Yes, he did.
And do you recall what you told him?
I told him that no, it wasn't the only copy.
And did he ask you what you had done with the other copy?
No.
Did he ask you not to give it to anyone?
No.
Did he ask you to maintain it or keep it preserved in some fashion?
No.
Did he tell you what he intended to do with his?
No, he didn't. It's other than take it that day and pass it along.
And is it your testimony that you erased it in March or April because he told you you were not going to be called as a witness?
No, because he had told me a long time before that. I taped over it because I needed a tape.
So it just happened that it was in March or April of '95?
Right.
Okay. Nothing further.
Ms. Stockdale, do you still have the tape, physically the tape itself that you taped over?
I believe I do. I've been looking for it.
You've been looking for it, but you haven't found it.
Yes.
All right, do you know how many times you've taped over that tape?
A couple times.
Makes it a little more difficult.
Barbie's a liar. I didn't know Barbie was like my Barbie. Never lied. Never, never, never.
All right, do you have any objection to if Prestige Voicemail still has the original message on their information systems there? Do you have any objection to the parties getting a copy of that phone message?
No.
All right, do you have any idea how a New York newspaper wound up?
That's a mystery to me.
All right, thank you very much, Ms. Stockdale.
Thank you.
All right, Mr. Nolan, thank you.
With respect to the authorization to seek her messages from Prestige, that authority would only go to that one message?
That's correct.
Thank you.
All right, anything else, counsel?
In the event that there is further service process, Ms. Stockdale, the council will accept service under that.
We'll accept it. We'll accept service.
All right, thank you, counsel. Yes, at this point, I think we need to discuss also the 1054.7 issues with regards to this tape. All right. Ms. Clark, anything else you want to add to the record with regards to Ms. Stockdale?
Factually speaking, perhaps we have a conflict here, and maybe what we
Yeah,
need to do
Richard,
is
it could have
call
been
for a
you
conflict.
that night.
Unless,
I'm glad you're safely in Australia.
I don't think that is, actually.
Well, the issue was whether or not Ms. Stockdale had a copy that was still available. She's indicated that she taped over the tape a number of times, so in all likelihood, it's not recoverable, except for perhaps by the NSA, and I don't think they're going to help us with this.
Fairly doubt, Your Honor. And that was back in March or April of '95, before we could have known.
Now, have you made inquiry of this phone voicemail service, whether or not their database still includes this? Because you've gotten authorization from her to get the original from the digital format.
This is the first we've heard of it, Your Honor, so we will do so.
All right.
So does the court want us to make that effort to get that before we resume with argument on this issue?
The defense previously, under 1054.7, filed affidavits regarding this particular tape. And Mrs. Robertson will need to get that sealed package. All right. But I do think that you ought to, at this point, I'm going to direct you to contact the voicemail service and see if that database from that date is still available.
The people would make a motion then for those 1054.7 materials, though, to be discovered at this time as well.
All right, I'll take that matter under submission. All right, but I'm going to direct you to contact the voicemail system this afternoon, and Bruce Humiston was the name? Humiston.
And then we'll revisit.
We'll see where we are at that point.
The 1054.7 submission, Your Honor, was to preserve the defendant's work product privilege. We don't believe that they're entitled to see that, but the only theory under which there's any duty at all to turn this over would not arise under 1054, but under the Meredith case. And that's whether we have foreclosed access by the prosecution by taking physical possession of...
That's why I'm directing, I'm putting them on notice that that exists, that it's still in sealed condition. I'm directing them to go to the original source at this point.
Right.
Right. We have no dispute about Meredith controlling on this issue.
Well, we contend Meredith doesn't apply because it's not inculpatory evidence and because we have not foreclosed access. So for both of those reasons.
All right. Well, we already framed this one for the court.
It may become a non-issue later today.
Yeah.
All right, anything else we need to wrestle with this afternoon? All right, then we'll stand in recess until 9 o'clock tomorrow morning with regards to the IAD issue and finding materiality after the city attorney's office, after the defense files its declaration of materiality. Court will hear orally any argument that the city attorney's office has. I'll hear comment from the district attorney's office as well. And then I'll hopefully be able to make a ruling on the prima facie materiality issue at that point.
That's just as the IAD.
Right. Well, this is the whole issue, though. That's one small part of a larger issue. Because, I mean, that issue includes, Dr. Reeders, it includes McDonald. I mean, it's the whole issue of blood on the socks is what the issue is. And then I think the defense should be prepared to go forward with its next witness at 1 o'clock tomorrow afternoon. 1 o'clock. 1 o'clock tomorrow afternoon.
And we're going to do as best we can. We may not have enough for the entire afternoon if we don't get back to that hour.
Well, make your best efforts.
I will.
All right. Anything else? All right, we'll stand in recess. Thank you, counsel. On the showing of materiality on a subpoena request for certain documents alleged to be in the custody of the Los Angeles Police Department. And the issue that has been left for this court to determine is whether there has been an adequate showing of materiality to justify the request. The court has received this morning a declaration by counsel, Mr. Allman, which is 4 pages in length, which the court has read and considered. Mr. Allman, I'll hear any additional comments that you may have.
Your Honor, in the declaration, we have attempted to summarize all of the evidence, most of which is already in the record, with respect to the issues that we believe this report is material to. And those issues include whether the criminal investigation of these murders was an objective search for the truth, or whether it was a rush to judgment in which only evidence that supported a preconceived conclusion of Mr. Simpson's guilt was actually pursued. Whether evidence in this case was deliberately tampered with or manufactured, and we believe that a strong inference of such activity would arise if LAPD officers or personnel were confidently leaking results of DNA tests that had not yet been conducted. Thirdly, whether leaks by the LAPD were an attempt to obstruct justice by influencing potential jurors at the time that jury selection in this case was proceeding. Fourthly, whether any witness in this case testified falsely by denying complicity in either a conspiracy to frame Mr. Simpson or a cover-up of misconduct by other members of the Los Angeles Police Department. And finally, whether unauthorized persons had access to the test results to leak them. We believe it's a fair inference that if unauthorized persons had access to confidential reports summarizing test results, then they may well have also had access to the evidence itself and could have tampered with it, since we're told the reports and the evidence were being kept in the same location. I would also ask that
Where
the
in
court...
record does it show that the evidence and the reports were kept in the same place?
The faxes to SID that were leaked and appeared in the Los Angeles Times before they went to the prosecution and the defense had been faxed directly to the SID laboratory to Michelle Kessler. So if there's some argument that and that argument has been made by Mr. Goldberg, that this could have been an interloper. If interlopers had access to the SID laboratory for this purpose, there's an inference that they may have had access for other purposes as well. We, of course, would contend that all of these issues are essentially the same issues as to which the testimony of Tracy Savage and Joe Bosco would be relevant. And in light of the crossover really between this motion and the motion with respect to piercing the newspaper shield law, would ask that this declaration also be considered for that purpose, for purpose of the newspaper shield law motion. And in terms of crossover, if the court does have an opportunity to examine the internal affairs report, that report should also be considered for whatever relevance it may have to the reporter shield law issue in terms of alternative sources.
Thank you, Mr. Allman. Mr. Walsh?
Thank you, Your Honor.
Good morning.
I am not at all familiar with the facts of this case, and so I accept the representations of Mr. Ullman regarding the facts as being correct. I have no reason to doubt them. Certainly lays out a lot of facts regarding evidence and
I have
reports
reason
the
to
press.
doubt them.
What is noticeably missing
Everybody's
from this declaration,
lying.
however, is anything that ties those facts to the defense's desire to find out what internal affairs may have learned when it looked into those leaks, assuming that it did. There is no demonstration that anything regarding Los Angeles Police Department or the source of the leaks has any materiality to the issues which I believe are present in this case. I find the format followed in the declaration to be significant of the logical gaps. After making a series of direct factual statements, Mr. Ullman concludes his 4-page declaration by posing 5 questions. Did this investigation support a preconceived conclusion? Was evidence planted? Were they attempts to influence? I don't know the answer to that. Apparently, not only does the defense not know the answer to that, but they don't even have a good faith belief in what those answers might be, because they do not articulate that they have a good faith belief that any member of the Los Angeles Police Department in fact was responsible for the leak or in fact had some nefarious motive for being involved in leaking this. And this is what is absolutely missing from this, and what that is necessary for is to show materiality between what might be contained in the internal affairs report and the theories of the case being presented by the defense. One of the major cases on the issue of materiality is the Memro opinion. I don't have that citation in front of me, but a California Supreme Court case in which an individual sought discovery of police officer practices of abusing prisoners and coercing them into confessing and then covering up their illegal behavior. And in support of the request for discovery in that matter, the defense attorney presented affidavits in which other criminal defendants reported having had similar events occur to them. And despite having presented this firm affidavit, the trial court declined to order discovery. Our Supreme Court said that there was more than enough presented in that case to demonstrate the materiality of the matters presented. In this declaration, there is absolutely no suggestion that at any time any member of the Los Angeles Police Department, in this case or any other case, has engaged in leaking information for the purposes which apparently the defense wants to put forward. Basically, the defense here is bootstrapping the fact that this is almost certainly the most publicized criminal case in modern history, a case which has drawn more media attention and been subjected to more media pressure than any case that anyone else has ever had any contact with. And having observed that it's subjected to that kind of pressure, stated, well, this proves that LAPD must have some ulterior motive in being subjected to this pressure. If the Los Angeles Police Department in other murder cases, and if the Los Angeles Police Department in other criminal investigations had developed even a bad reputation, a minor reputation for engaging in the kind of conduct that the defense suggests occurred in this, then perhaps there might be some justification. If the defense alleged that the police department had a pattern and practice of engaging in leaks and planting evidence and framing individuals, then there might be some justification for intruding into the confidential material here. All of that, however, is completely lacking from this declaration, and I would urge the court to find, therefore, that it lacks the necessary materiality.
All right, does the district attorney's office wish to be heard on this issue?
Yes, sir.
All right, Mr. Goldberg?
Good morning.
Good morning, counsel.
I know we've discussed this on, I think, 2 prior occasions, the issue of materiality, so I'll try not to repeat any of the previous arguments that we've made, both orally and in writing. But there are a couple additional comments that I'd like to make in light of Mr. Ullman's declaration. Basically, the declaration, I think, can be divided up into 2 sections. The first one would be everything before the last page that has the outline of the questions A through E. The second one being those list of questions that Mr. Walsh discussed. With respect to the first part of the declaration, Your Honor, the people have not argued for the purposes of this motion that the defense is not entitled to pursue the theory that the evidence on the socks or the socks themselves were planted. Obviously, they are entitled to do that, and they have been doing that. What we are questioning is whether or not the evidence that they'd like to introduce as to the alleged leak, if indeed it was a leak, has any probative value or any materiality as one of the fragments of evidence that they want to introduce for the purposes of making that showing. Therefore, I don't want to argue extensively about the parts of the declaration and what I've characterized as being the first part, except to point out just one thing, and that is that with respect to paragraphs 4, 5, and 6 of the declaration, dealing with the circumstances under which the socks were collected, when Mr. Ullman last addressed the court on this issue, he specifically stated that the defense was not claiming that the socks themselves were planted, and therefore the issue about when specifically they were picked up did not go to the question of planting, but went only to the issue of whether or not the socks were properly collected and properly documented, which would be more of an evidence collection issue. So they do appear to be mixing apples and oranges here and appear to be analytically imprecise with the court in identifying exactly what facts go to which issues, because this fact does not go to the question of planting, and I'd say that clearly the issue of the leak also does not go logically to the question of planting. So it's a question, Your Honor, of identifying what are we trying to prove, or what is the defense trying to prove, and does this piece of evidence in question have a tendency and reason to help them prove that? Now, in the second part of the declaration, on the list of questions that they articulated, A through E, I've divided those up into 3 categories. Category number 1 is what they labeled as the rush to judgment. That's paragraph A. Then the second category I have is paragraph C, which are the supposed efforts by the Los Angeles Police Department to obstruct justice. And then I've labeled everything else as argument number 3, and that goes to the planning issue. And I'd suggest that that's the only one that the defense should be discussing at all, that the others are complete red herrings. First of all, as to the question of rush to judgment. We have stated, and I'd just like to state one more time, I know that there has been some evidence that's been introduced, some questions along these lines. I don't know whether they were objected to by the people at the time. But the issue of the subjective reasoning processes of the prosecution, including the prosecutors themselves and the detectives, is entirely irrelevant. The whole issue of rush to judgment, if it refers to subjective reasoning processes of police and prosecutors, is not a relevant admissible issue in and of itself. If it were, we would be entitled to testify, the prosecutors in this case, as to why the case was filed, what our filing standards are, how we personally assess the evidence, or would be able to call an expert witness like a police officer for the purposes of showing how a reasonable police officer would assess those kinds of issues. That clearly is not admissible in any criminal trial. The issue is whether a jury objectively viewing this evidence believes that it is sufficient. Whether I think it is sufficient, whether Detective Van Adder thinks it's sufficient, is entirely irrelevant and inadmissible. And I think the entire issue of rush to judgment in and of itself is not a real or legitimate issue. Therefore, since that issue is not a legitimate one, any evidence that theoretically supports that issue is not admissible and is not material. Aside from that, I'd suggest that the issue of the leak itself, even if we were to conclude that rush to judgment was a legitimate issue, doesn't really logically relate to it. How does the fact that someone has either negligently or intentionally released information relate to whether or not subjectively they should have concluded that there was sufficient evidence to prosecute the defendant in this case? The second argument that I'd like to discuss that the defense makes is this issue of paragraph C, where they say that the leaks would evidence an attempt to obstruct justice by influencing potential jurors. At the heart of this argument, and in fact at the heart of the third argument that the defense makes on the planning issue, seems to be the assumption that a leak or a statement to the police, by the police to the press, or by the prosecution to the press, is somehow improper, which has been an unstated assumption that we have all made in all of our discussions to date. The fact is that under the California rules of ethics that apply to lawyers in our state, we don't have a provision dealing with communications by lawyers to the media. Therefore, if the lawyers themselves were to run out onto the courthouse steps and say, oh, there's tremendous news, we've just found Nicole Simpson's blood on the socks, we would not have violated any ethical provisions in doing so. We would not have violated any court order, because my understanding is that the court never did employ any kind of a gag order. We would not have violated any rule of law in doing so. We would have only violated a custom that we have in our office of not engaging in that kind of an effort to try one's case in the media. But clearly the defense, on a number of occasions, including with respect to the Mark Furman issues that the court will probably be shortly confronting, has repeatedly disclosed these kinds of materials to the media, and they have not violated any rules of ethics in doing so.
You know, I did tell you guys
I don't think
that
they would claim that they have done anything improper. So there is
this is like an audio only type thing. Like, I can't show it because the way I recorded the live stream, there was something covering up the video. So while I was at work, I pressed record while I was at work, and I don't know if something popped up or whatever. It just covered the whole video. And so there's no video. It's just audio and us talking in chat. That's all it'll be.
Nothing per se improper under current California rules of ethics in making disclosures to the press, even though individual prosecutors or individual defense attorneys may feel that these kinds of things should not be done. If the investigating officers did the same thing, I gave the court a hypothetical where someone in the elevator was overhearing a discussion between Lang and Van Adder and then repeated that to the media and suggested that there's no conceivable theory of admissibility of that kind of disclosure. But let's say Lang and Van Adder themselves made the disclosure to the media. There might be individual police officers that would criticize that decision and say that it was improper, but still they would not have violated any rule of ethics, any rule of law.
Isn't that sort of implausible, since Lang and Van Adder, given their experience as police officers, would know the difference between PGM subtyping and DNA results?
I really don't know, Your Honor. I mean, let's say, we have to discuss this thing almost on a hypothetical level because the defense hasn't come forward with any specific concrete facts as to materiality. So let's assume that what happened is that they received a call from Mr. Matheson or Michelle Kessler or both, and they said, well, we've just done some PCR. We just done some genetic testing, or testing for genetic markers on the socks. And according to our tests, the PGM results would include Nicole Brown as being a contributor to the stain. And they interpreted that, well, PGM, DNA, it's, both three initials, it's genetic markers, it's Nicole Brown, and immediately, excitedly disclosed us to the press. I would suggest that although that would be perhaps a very curious set of circumstances and maybe a careless set of circumstances, it wouldn't be legally admissible set of circumstances, any more than the defense disclosures to the press are admissible.
A different issue.
What's a different issue?
The admissibility of that before the trier of fact versus a preliminary finding of materiality in a discovery issue.
Well, would it be material? I would suggest it wouldn't be, even if it were by the investigating officers themselves. It's not material on the issue of an effort to obstruct justice, and it's not material because there is no rule of law or ethics that had been violated under my hypothetical in making that disclosure. So it does not go to the issue of an effort to obstruct justice. So the point that I'm making, Your Honor, is I can't conceive of a scenario, even if it were the investigating officers themselves, where the evidence that the defense seeks would be material on the issue of an effort to obstruct justice. It wouldn't be if the prosecutors disclosed it or the investigating officers themselves, and certainly it wouldn't be if someone who was a police officer but not involved in the case made this disclosure. And then as to the third issue that they've discussed, or what I've labeled as the third issue, being the issue of planting of evidence. In paragraph E, they say that it's reasonable to infer that a person with access to the test results also had access to the SOX. Well, first of all, what we're talking about is the PGM test results in this particular case. And the people that had access to those were the prosecution, because we had been told of them, the investigating officers, the laboratory, and we don't know who else in addition to those people. We don't know for sure, can't reconstruct at this point in time, whether that might have been told to the defense attorneys orally. We certainly don't know what kinds of individuals may have overheard that information, but it's a very wide circle of people that had access to that information, and clearly the prosecutors did not have access to the SOX. Detective Lang and Van Adder did not have access to the SOX. There are no uniformed members of the police department that had access to the SOX, so this is just plain false. But it's been repeatedly argued by the people and by Mr. Walsh, there is no logical connection between the idea of the so-called leak and the issue of evidence planting. I think it's what logicians call a fallacy of the assumed premise, and that is that what they have said is there's a leak, therefore it's more likely that evidence was planted on the SOX. But in order to make that argument, you have to show a logical connection between the two, or a nexus between the two, if you will. And that nexus is entirely absent, because why would someone, if we were to infer it was someone who had access to the SOX that leaked this information, why would that person, knowing that there had been evidence planted on the SOX, then not only want to leak information to that effect, but leak it incorrectly, and therefore perhaps undermine any probative value that that evidence would have subsequently, to the extent that the public learned that information that was incorrect was being leaked by the Los Angeles Police Department. It simply doesn't make any sense that someone who had planted the evidence on the SOX themselves or had knowledge of it would want to do that. And clearly, if the person that is responsible is not an individual with access to the SOX, then there is no conceivable argument showing a nexus between the so-called leak and evidence planting. So if the court is very systematic in going through point per point the three arguments that the defense has made as to materiality, in this systematic way, I think the court should conclude and will conclude that there is no materiality to the question of the so-called leaks in this case, that it does not prove any fact that the defense is entitled to prove in this case. Thank you.
Mr. Ullman? I'm particularly interested in the last point that Mr. Goldberg makes, that access to results does not necessarily imply access to the evidence itself. And he has implied argument that the access to the results here is not proven, because the misinformation that was disseminated rather than the accurate information would indicate to an objective person that the person didn't have access to the results.
Let me address that issue first then, because the suggestion that the report of the investigation into the leaks would be material in this respect is really an alternative argument. What we're suggesting, Your Honor, is that the evidence of where the leak came from is going to be relevant and material in either alternative. If the leak came from the LAPD. It's going to be material to the evidence we have already presented in this case of the planting of evidence. I mean, we're not dealing with remarkable coincidence. We are dealing with the concurrence of two events that we believe there's a very strong inference of a relationship between those events. One, the appearance of blood stains on the socks long after they were collected, and the first results of the testing of those socks, and at the same time the appearance in the press of accounts of tests of those socks that had not yet been conducted. So if we link the leak to the LAPD, I think we have a very strong inference that these two events are related. But alternatively...
Let me ask you this question. When you say we link this to the LAPD, I mean, are we talking about some P2 in the elevator who happens to overhear a conversation and that establishes a substantial link to the LAPD?
Well,
or are we talking about somebody who's involved in the investigation?
Okay. And
had
my
access
answer to that is either way. Either way. If it goes directly to people who are involved in the investigation, we have a very strong inference of direct evidence planting.
But doesn't the evidence show the contrary?
Well, if it did, we have a real problem in terms of security and chain of custody. I mean, what we're saying is, even if we don't link this to people directly involved in the investigation, the mere fact that a P2 in the elevator gets
with no
access
evidence,
to...
What if Marsha Clark was really the killer? Why don't you say that if? You can't just if things.
Test results suggests that the kind of security that the prosecution would believe has enveloped this evidence and protected it and maintained its sanctity and its purity is not believable. Because a P2 in the elevator can walk into the SID and get test results. And that's...
No, that wasn't the point I was making.
Well, what I'm suggesting, Your Honor, is that there's an alternative here. And either way that it comes out, we have material, relevant evidence that the jury is entitled to hear. On the one hand, if it's linked directly to LAPD officers or laboratory technicians who were involved in the investigation of this case, or if it turns out the leaks came from some unauthorized person who got access to this information from the LAPD. Either way, we believe it's material. And that's the precise point. The question of the issue that Mr. Goldberg suggests mixes apples and oranges, for example, the question of the actual collection of the sock, goes right to the point of the issue of the security with which this evidence was maintained. That is, if we can't even trust the accounts of the criminalists who collected the evidence, if we can't trust the records they maintained as to when that evidence was picked up, then how can we believe the evidence that they're presenting with respect to the security with which this evidence was maintained? We're dealing essentially with a chain of custody issue here in terms of whether the evidence is even credible that this evidence was protected and secured against tampering by unauthorized persons. And that's the relevance, and it ties directly to the issue of whether there has been evidence tampering, the fact that this very same evidence, whose integrity is being questioned, was sloppily handled from start to finish. And that's the relevance of the circumstances regarding when the socks were picked up. I want to respond very briefly to Mr. Walsh's points. Essentially, he's criticizing the affidavit because it doesn't come to a conclusion about what we believe these records will ultimately show. And that's, of course, because we haven't seen the records. The issue of materiality simply goes to whether there is a likelihood that in these records there will be relevant evidence to issues that we are litigating in this case. I think the affidavit amply shows that in the evidence already presented to this jury, we have ample materiality and relevance to the question of where the leaks came from. The question of where the leaks came from relates directly to the issues we are already litigating and have already presented to the jury in terms of evidence tampering in this case. He says there's nowhere in this affidavit any suggestion that an LAPD officer was responsible for any leaks. And I would call his attention to paragraph 16, which recounts the testimony of Mr. Bosco.
Bosco did not identify the individual as an LAPD officer.
I believe his published report indicated that it
No.
was an LAPD officer.
Does not.
I hope I'm not overstating that, but...
A police officer, and I think it says a police officer, does not identify him as an LAPD officer.
A police officer, as opposed to an officer of the Los Angeles Police Department. Well, I think it's a very fair inference that officers of the Inglewood Police Department or the Beverly Hills Police Department weren't passing out lab results, that the police officer in question logically and inferentially would have been an officer of the Los Angeles Police Department that was conducting this investigation, especially in the context of the report, which talks about the history.
All right, well, Mr. Allman, let me ask you this, though. The bottom line here is whether or not the leaking of misinformation implies evidence tampering. That's the bottom line issue. And
Well, we believe it's broader than that, that even the leaking of prior information, other than just this one false report of results, is also relevant to the questions that we are addressing, the questions of the rush to judgment, the questions of attempting to influence the outcome of the case by leaking results. And Mr. Goldberg, I think, really misconceives the thrust of that argument. If lawyers or police officers went out on the courthouse steps and passed out this information publicly, they could be held accountable. They would then accept responsibility for what they were doing. And accepting responsibility for what you are doing means accepting the consequences of what you are doing. For example, the Los Angeles Police Department accepted the responsibility for distributing the 911 tapes at the time that the grand jury was still considering whether to return an indictment in this case. It was, I believe, directly as a result of showing that responsibility, of showing that that leak came from the Los Angeles Police Department and was responsible
it
for...
wasn't really a leak. It was done above board. There was nothing surreptitious about it.
Exactly, exactly. And for that reason, we were able to point to the Los Angeles Police Department and to say, a climate is being created by the prosecution in this case and by the investigating officers that prejudices the fair consideration of this case by the grand jury. That's precisely what we want to say to this jury and to this court in this trial, that the responsibility of the Los Angeles Police Department for leaking this information was designed to create a climate that would prejudice Mr. Simpson. That is relevant evidence with respect to the weakness of their case, if they accept responsibility for it. But the problem is, we're talking here about surreptitious leaking. We're not talking about going out on the front steps of the courtroom. We're talking about passing out test results out the back door. And what we're trying to get at in this case is who's responsible for that. And that is an issue that we're entitled to present to this jury if we can show that the Los Angeles Police Department is responsible for that. And that's precisely what the materiality of this report is, to help us resolve that question. With respect to the question of the rush to judgment, that goes directly to the motive to plant evidence in this case, and has already been the subject of testimony from numerous witnesses, including Detective Van Adder and Lang, with respect to how this investigation was conducted. And we're certainly entitled to counter that evidence with evidence that there was leaking activity going on in order to support a preconceived result in this case. So we would contend, no matter how we cut it, if the leaking of this information can be attributed to officers of the Los Angeles Police Department or laboratory personnel who were involved in this case, it is strong corroborative evidence of what we have already presented with respect to the planting of evidence, the manufacturing of evidence, and the lack of integrity of the evidence in terms of the security that was maintained over that evidence. Alternatively, if where it leads us is to show that some unauthorized person, some elevator operator or whoever, was responsible for the leak, it goes directly to that security issue, to the chain of custody issue, and to raising questions about whether, in fact, the evidence was maintained as securely as the prosecution would have us believe in terms of the unauthorized access of other persons to testing results.
But doesn't elevator gossip, isn't that a big leap to the security of the actual physical maintenance of the evidence?
I don't believe it is that big a leap. I think it's a fair inference that if the Los Angeles Police Department, besides being a cesspool of contamination in their laboratory, is also a cesspool of gossip, in which an investigation is conducted in a way that this kind of information is readily available to anyone in the building, then that says a heck of a lot about the risks that we're talking about in this case, that persons who should not have access to information and evidence did have such access.
All right, thank you, counsel.
Your Honor, I have the cite to that case that I gave you earlier.
Memro?
People versus Memro.
I'm familiar with the case.
258.
All right, what we have here,
There's a failure to communicate. Nope, not today. You had your chance today. My breakfast is over, so we gotta go. I got work to do. Man, that donut was delicious. It really was. It hit. It slapped. All right, guys. It was so nice live streaming again. It went so fast, though. It's over now. I'll see you guys in a couple hours, though. We have that. All is fair in love and war and food. Food. I'm positive you ate something yesterday I didn't get any of. And I'm also positive. You want to hear his decision, Luke? Okay, let's go. Let's hear the decision. I also want to hear the decision. It's only a few more minutes. Don't say bye yet, T. I changed my mind.
No, and nothing.
because I've heard your comments on this particular issue twice.
No, I know, but actually probably more than twice. I think this is the third time. But the counsel did articulate a couple new theories. I did want to respond to them. If the court completely feels it's unnecessary, I won't.
No, it's up to you. You're the advocate for your side, if you feel it's absolutely necessary.
Well, I'd just like to respond very briefly. I think that it's very difficult for Mr. Ullman to precisely articulate any theory of admissibility. He seems to offer two new ones, and those are the only
It's not
ones
an
that I
issue
want.
of admissibility at this point. This is a preliminary discovery issue.
Materiality. One is the issue of security, and I think as the court's comments showed, or the court's questions showed, there is no logical connection, or would be no logical connection between two detectives whispering conversations as to PGM results that were overheard by a uniformed detective in an elevator, and the security of the physical evidence itself. And I don't think they can articulate any logical theory of connection. The second new theory that he articulated was that somehow any leaking would be relevant in and of itself, whether it's surreptitious or not, if I'm understanding what he's saying. Well, that would make the 911 tape information admissible, and I think he's saying that it would be admissible, even though it was done entirely above board pursuant to a request for information by the press. But that would also make the defense leaks admissible as well, if you want to call them that. I'm not sure that that's the correct terminology. And we try this case by introducing evidence as to the respective sides' communications with the press and any inferences that could be drawn from that in terms of the effect that we wanted that to have on the public. And that just is not a proper way of trying a case. He also seems to suggest that if any police officer in the whole entire police department has done anything to evidence any sort of a preconception or ill will towards the defendant in releasing information, that in and of itself is relevant. But that would make it relevant if some officer, when he's passing out traffic tickets, is telling people, well, you know, by the way, I also think Mr. Simpson is guilty and there's a lot of evidence against him. I simply don't believe there is any logical connection between a person in the police department who is not connected with this case passing out information on any issue that is material before this jury.
Just a very brief point. If we had evidence that the 911 tapes had been doctored or altered in some way, that voices had been planted on the tape, then perhaps the release of those tapes shortly after those alterations appeared would be relevant, and we'd be arguing that that the release of those tapes was evidence of many of the inferences that we're suggesting here, and that's precisely the point. That these socks, the evidence we have already presented, may have been altered very shortly before the release of this information, and the first test of the blood that was not observed on those socks until 3 weeks after they were seized were conducted 1 day before this leak took place. And the fact that a leak appears at that time and in that manner with respect to this evidence goes precisely to the question of materiality.
Thank you, counsel. All right, what the court has before it essentially are two issues of materiality. One with regards to the good cause to issue a subpoena ducis tecum for the production of documents, and secondly, whether or not sufficient materiality exists to compel Mr. Bosco and Ms. Savage to reveal the sources of their information. Both of these are in the nature of a preliminary finding regarding discovery. And what is required is that a party show a reasonable possibility that the information will materially assist in their case. The primary contention that the defense makes is that the blood of Nicole Brown Simpson was planted upon LAPD item 13, which was the sock recovered from the defendant's Rockingham residence master bedroom. There's a further argument that the source of this blood on the sock was the reference sample obtained by the coroner's office. The record reflects that Detective Adalberto Looper directed the recovery of the socks, item 13, from the bedroom of Mr. Simpson because the socks looked out of place. He did not make any observations regarding the presence of blood. Criminalists Fung and Mazzola, working as a team collecting the items from the upstairs bedroom area, they collected items including the socks, and at that time did not notice the presence of bloodstains. LAPD SID personnel Kessler, Matheson, and Yamauchi, on or about the 29th of June, conducted an inventory of the evidence items during the course of the preliminary hearing, and at that time no bloodstains were noted on the socks. The court has before it the partial testimony of Dr. Frederick Reeders. Dr. Reeders has conducted an analysis of FBI Special Agent Roger Martz's testing of various bloodstain items, including the sock item 13, and it has been the testimony of Dr. Reeders on direct testimony by the defense that the results obtained by Special Agent Martz are consistent with the presence of EDTA on the sock. Herbert McDonald, who testified for the defense as a blood pattern expert, indicated that his microscopic examination of the sock indicated that the blood on the sock was applied in a compression manner, that the sock had soaked through from the left, the blood had soaked through the sock from the left exterior to the left interior at the ankle level into the right interior, which led him to the opinion that the blood was applied while the sock was lying on a flat surface. Now, what transpired on or about September the 21st was a news report, primarily on KMBC Channel 4, locally here, that certain test results, DNA test results, both PCR and RFLP, had been conducted on the sock and had come back with a genetic match for Nicole Brown Simpson. And the record also demonstrates that that information was incorrect. Ms. Savage testified here before invoking the news media shield that the source of her information was, quote, knowledgeable and, quote, close to the investigation. Mr. Bosco testified that the information contained in his Penthouse article in the June 1995 issue was a correct reporting of the incidents that he related. And specifically at the page citation that he gave to us, he indicated that a police officer who had previously given mostly good information and had provided that information with corroboration was going around with information indicating this DNA match, and that Mr. Bosco, because no corroboration was offered, declined to follow up on that. Mr. Bosco's article also indicates that this information was provided to and rejected by numerous journalists. This leads to the argument that access to results also implies access to the evidence. This record does not support a finding that access to the results means access to the evidence itself. That assumes that access to the results does exist in this case. And the mere fact that the results as reported were incorrect is a clear indication to this court that the source of this leak did not have access to that information and was not a source close to the investigation and was not in fact knowledgeable. The Delaney case requires that the materiality or the offer or the argument in support of materiality cannot be mere speculation. And I think that the a record in its totality here, the court having considered the entire record, does not support a finding of materiality. All right, we'll stand in recess until 1 o'clock. Mr. Gelbert.
On an unrelated matter, I asked Mr. Douglas, the court will recall yesterday that the court ordered Mr. Shapiro to turn over this morning any notes of either Dr. Baden or Dr. Wolf if they were intended as witnesses in the case, and also to present exhibits that have not previously been marked so that I could preview them. I came down in hopes of seeing Mr. Shapiro and having access to any such notes. Not seeing him, I asked Mr. Douglas what the situation was, if Mr. Shapiro was going to be attending this morning and so forth. I don't know what the results of Mr. Douglas's efforts, if any, of ascertaining that information is, but needless to say, I would like compliance with the court's order, and I know of no other way to
All right,
make the
let me direct you then to call Mr. Shapiro's office as soon as we take our recess. If we need to, we'll take the matter up at 1 o'clock.
Thank you, Your Honor.
All right.
I got it, Your Honor.
All right.
Can we approach?
Sure.
Okay, this time it's for reals. This time it's for reals, because I got to get the garbage out. The garbage man's coming in like 20 minutes. This is me leaving everything for the last second. Whatever. You know what? Whether it gets done last night at 8 p.m. or this morning at 9:41 a.m., it's still getting done. Right? So if the trash man comes early, I learn a lesson. If they don't come early, I'm great at time management. That's how that works. Right? I could wake my son up and make him do some work, but I'm just going to do it myself this week. Let him sleep. He has a full-time job now, and he complains that his feet hurt. And when he does, like, I see red. Like, my anger doesn't... There's no words to describe my anger when my son says, after working 1 8-hour shift, oh, my feet hurt. Your feet hurt? Do they really? Does your feet hurt? Do you want me to get you a chair so you can sit down? Because your feet hurt? Yeah, I know, I'm his mom. I'm supposed to sympathize. I don't sympathize. No, not when I'm working doubles. I don't care if your feet hurt. Get to work. If your feet hurt, that means you're not working hard enough. You gotta work until they don't hurt anymore. Then talk to me. I can't tell when my feet hurt because my back hurts so bad. Talk to me then, sir. I got these lidocaine patches, and when I get off work, you're only allowed to use 3 patches at one time, which I never do. But when I get off work, I take the lidocaine patch. Wait, I thought I had one right here. Oh, yeah. And they're like triple this size, and I cut little strips, okay? And then I begin. I allow myself X amount of little strips, all right? I can't go over 3 patches. Now, I can't tell what hurts, because usually something hurts outstandingly more than something else. So, like my ankles. Whew. So, I start there. I take 2 and I put them on my ankles. When this starts to work on my ankles, then my body starts to tell me what other parts really hurt that I couldn't even feel because my ankles hurt so bad. So it's like I put them on and then I wait like 30 minutes and then I know it's time because I can feel, oh man, my back, okay, boom. Slap another one on, and then my feet, slap another one on. And I keep going until I'm out of the little strips that I had pre-cut, and then I know how many I'm allowed to have on, and you're only allowed to wear them for 12 hours tops. Oh, Josh. Oh, man. Oh. I don't even know, though. Like, yes, but man, I just feel like it hurts so, my back hurts so bad that they're just going to hurt me. Someone massaging me might just add more pain to that. I don't know. I just don't know. I don't know. There's a new spa that opened right 2 blocks away from me. So, I don't know. I've been thinking about support your local businesses. I am huge on supporting local. Buying your Christmas presents, birthday presents, blah, blah, blah. Shop local. Small businesses. Do that. Don't just buy on Amazon. Don't. Just don't. You don't have to. You can go to a local shop and get a gift for someone. Like, sorry. The people in your circle, they don't need whatever they're wishing for. They don't. They just go to a local business and get them a thoughtful present. And that helps everybody. Every single person. Except for the spoiled, entitled people who said, you know, I wanted this from Amazon and you got me this. They don't deserve a present anyway. They just don't. Support local. Except, never mind. No, just support local. Even them. Even those local. Just support them anyway. It's better than supporting conglomerates. Just is. I gave a couple people spas for presents. Because they're so nice. You know? Anyway. Maybe we should do a spa day. We all take off. We all go to the spa the same day. I haven't coughed in a long time, and now all of a sudden I'm starting to talk. I start coughing. That figures. All right, guys. See you in a couple hours. Try to get some sleep if you can. Okay? Bye, guys. Don't expect a lot from today. Keep your bar low. It'll help us both. Thanks, guys. Bye.